Busy hour this morning. We had a Washington County Executive Josh Schoen talking about a lot of things, including election integrity, which is a nice segue. Some of the conversations we're going to have with my friend and often guest on the program, Rick Esenberg, president of the Wisconsin Institute for Law and Liberty. Good morning, Rick.
Good morning, Steve. How are you?
Wonderful on this Thursday. So let's do a couple things. I'm going to ask you sort of an informal one, then we'll get to some of the other questions. Do you, as a legal mind, attorney, somebody who's argued cases in front of the Wisconsin Supreme Court, somebody who knows of what he speaks, do you find yourself watching the hush money trial on TV? The coverage of it, rather, because you can't see the case.
No, I tend to follow it on the podcasts and online. So, for example, if you want a very good analysis, a pretty much straight down the line analysis, albeit by a more conservative writer, Andy McCarthy at National Review is just fantastic on some of this stuff. But I do pay attention to it because it's really a fascinating mess.
Right.
From a legal perspective.
Early on, you told me that this case shouldn't even have been brought, and here we are.
It's gotten worse. The way it's been conducted is just I was going to say it's laughable, and Steve, the thing it reminds me of, for your older listeners, it reminds me of the final episode of Seinfeld. Right. And for those of you who have HBO, it reminds me of the final episode just recently of Curb Your Enthusiasm.
Yes, also.
Because the trial has been conducted in a way which basically has allowed the prosecutor, and the Trump strategy to some extent has played into this, allowed the prosecutor to put on a lot of evidence that really doesn't relate to the charges, but relates to just how bad a guy Donald Trump is. And, I don't think the case should have been brought. I don't think that there's a felony here. But, if you as a prosecutor have an opportunity to, put on evidence about what a bad guy Donald Trump is, you're going to have a field day.
That's right. Do you see this case actually getting to a jury and a jury saying, yes, he's guilty? I don't see that happening.
Well, it shouldn't. I think first of all, the judge should have dismissed it. The judge probably should enter a directed verdict. But a lot of the evidence that we're hearing now really doesn't matter. It doesn't really matter if he had an affair with her or not, or whether the affair was creepy as it was. It doesn't really matter if he paid her money to shut her up. That's kind of gross and creepy too, but it's not illegal, and it's not a violation of the campaign finance laws. And so the problem that they have is that you can make a case that calling this legal expenses was wrong. It really wasn't that. And so that the books were, falsified, but they have to be falsified fraudulently. You have to be trying to defraud somebody, and that simply didn't happen here. It couldn't have been an effort to affect the outcome of the election, because nobody would have seen these books before Election Day.
Let me ask you this legal question. So when you have, if you're trying to prove fraud, financial fraud, can you submit evidence in paper, like whatever, and I'm sure they have tons of paper boxes filled with this evidence, and not have witnesses that have nothing to do with that, but have more to do with the conduct of the president? Is that putting on a good case?
Well, no, that's what I said. This is like the last episode of Seinfeld or Curb Your Enthusiasm, where basically the dramatic device was to have, a bunch of people who were on the shows earlier come in and testify about, how bad on the one hand, Jerry, Elaine, and Kramer and George are, or Larry David in the second one. And really, that's all kind of that's irrelevant and actually prejudicial, because the question before the jury is, not did Donald Trump have a scuzzy affair and act like a jerk, but are the elements of this particular crime met? And I think for people who don't think in these terms, that really is the key in any criminal trial. You have to point to you can't just put somebody on trial because you think they did something wrong. You have to identify a criminal statute that they violated, and that criminal statute will set out a number of elements, and you have to show that each of these elements are met. And the problem when you let in a bunch of testimony about what a bad guy the defendant is, then you risk undue prejudice of the determination of whether the criminal statute was violated.
All right, we'll take a break. Talking to Rick Esenberg, president of Wisconsin Institute for Law and Liberty. After the break, Wisconsin's new majority, Wisconsin Supreme Court's new majority, looking at the 2022 ruling on the question of absentee ballot drop boxes. Rick and I have talked about this before. I want to get his latest take on that. That's all coming up after the break. The Political Power Hour Legal Edition right here in WTMJ. Political Power Hour, Thursday edition. My guest, Rick Esenberg, joining us on the phone. Rick, you and I have talked about this before. Let me ask you a layman's version of this question. The words ballot box are not in our state law, at least the historical state law that says that we don't allow for them or ban them. So I guess this is a general layman's question. If something's not explicitly in there, can it exist?
Well, I wouldn't put it that way. So the question is, how do you return an absentee ballot? And, you could imagine 100 different ways to return an absentee ballot. But when you look at the statute, it says that, it describes the process for voting absentee. And it says that the elector shall either return the ballot to the clerk in person, or will place it in the United States mail. And so when you say that the way that you return this is A or B, then that necessarily means you don't do it by C, D, E, F, G, and H. And so even though there's no explicit provision that says you can't have a drop box, there is an explicit provision that says you either return it this way or that way, which means in the English language, there's no other way that you return it.
Is the state law as specific about how we count our votes? Because I'm sure you've seen this, the town of Thornapple, Russ County, they basically voted to not use any kind of electronic counting. I mean, we have computers for a reason.
They don't. Yeah. So my understanding is that you don't have to use electronic counting, but the problem that presents itself, the legal issue that comes up, is that you have to have under federal law some way to accommodate disabled voters.
Right.
And so the argument is, well, you need some kind of machine to do that, because these machines can apparently accommodate privately someone who is disabled and can't mark a physical ballot. And the argument is, and so with the people in Thornapple, who've listened to one of these cranks, what they're saying is, well, sure, we can accommodate disabled voters because we can have somebody assist the voter, which is specifically provided for in state law, and they can read the choices and mark what the voter says. And the argument against that is, well, but then the disabled voter loses the privacy of their vote.
That's a pretty big butt there, I think, right?
Well, it's a big butt. I don't know whether it's enough to make using hand-marked ballots only illegal under federal law, but in any event, that's the argument.
Let me ask you this question.
I think there have been some courts that have so concluded.
Let me ask you this question, and this is sort of one of those big ones, but you and I have both gone through all of the stuff that's happened since 2020. We've talked about it on the show. We've talked on social media. We all have our opinions about all the stuff, the review process, how we count votes, what the rules should be. Is there a part of you that says, okay, minus all the Trump nonsense, will there be a better process in 2024, the presidential election, than maybe there was in 2020? More review, more accurate. Is there a part of you that says, okay, maybe this will be better this time?
Well, it should be. So I think that a lot of issues were identified. I mean, I think what happened in 2020, and, we can put our partisan tilts on it. And in my view, Republicans tend to overemphasize voter fraud, but Democrats tend to overemphasize voter suppression. And so if you try to sort of put both of those a little bit off to the side and kind of look and see what happened, it's pretty clear that in 2020 there were significant departures from the rules surrounding absentee balloting, but perhaps you could justify at least some of this because of concerns arisen by the COVID pandemic. For example, this business of not allowing voting registers into nursing homes, that clearly was not lawful. On the other hand, they were in a real bind because you didn't want to have a bunch of people going into nursing homes at the height of the COVID pandemic.
Right,
I mean, that could be very, very dangerous, or at least the fear was that it could be very, very dangerous. And what they really needed to do in a system that was working better would have been to go to the legislature and get the thing fixed. I think that could have happened, but because of the polarization between the two political parties, it didn't. Hopefully in 2024, we don't have the concerns about the pandemic. We've got some judicial resolution on some of these issues, it's always difficult to resolve, thorny legal issues in the middle of an election. And so we can hope that, yes, that things will be better. And I have always said that the way that you instill public confidence in election is you follow the rules. And, we take a lot of heat because, we kind of our litigation basically insists on the rules being followed. But there's a reason that, we do that.
I think the phrase, Rick, is rules matter. That's the one.
Yeah. And I'm sorry, guys, use the analogy of a football game. You don't change the rules in the middle of the game because you think that, you have a better way to define pass interference. You can't do that. I mean, even if nothing wrong is going on, even if nobody's trying to cheat, it undermines public confidence in the process. The best way to do this is say, okay, these are the rules. This is how we're going to conduct the election. The election is going to be conducted, by, public officials who are, sworn to follow the law. And this is what we're going to do. And then at that point, when there's a winner and a loser, the thing that needs to happen can happen. That is, both sides can accept the results. Because, the thing about democracy is you got to be willing. You want to win. You try hard to win, but you got to be willing to lose and accept the results and then go on to fight the next election.
All right, quick break, and then we'll wrap it up with Rick Esenberg, president of the Wisconsin Institute for Law and Liberty. Real quick here, because I only got about 45 seconds. Rick Esenberg joining from the Wisconsin Institute for Law and Liberty. Rick, why is the Supreme Court taking so long on these presidential immunity questions? What's going on?
It's not taking so long. Actually, it'll be pretty quick if they decided at the end of the term. These things just take a long time. These are very complicated questions. They're unprecedented. As Alito said, this is going to be a decision for the ages. They need to get it right.
Rick Esenberg, always enjoy our conversations. Next time in studio, we'll talk longer.
All right. Take care.
Look
forward to it.
All right.